Who ate plenty of chocolate over the weekend? Not very many people. Who ate lots of chocolate? Lots? No? Who had a nice relaxing 4 days off? Some people. Who was studying for their audit quizzes? Not very many. Oh, well, hopefully we feel nice and confident then. Today is probably our biggest lecture of the entire semester, where we're actually going to cover two topics, and they sort of link quite closely together. And those are the legal environment, audit quality, and ethics. So we're actually looking at two chapters from this week's book. So next week's quiz will be on two chapters of the text. And also this week, and I'll put them on UTS Online for you, there's a whole lot of videos around legal liability as well. So I've done some videos giving an overview of legal liability. There are some good links to some videos out of the UK, a bit more on liability to third parties. And then there's a whole lot of other stuff as well related to this topic. So there's also some great videos to watch for this week. But I'm going to start something a little bit new that we're going to do every single week at the beginning of the lecture. And that's to create a concept map of what we know so far about auditing, and then each week we're going to build on that. Okay, so, all right. Let's start with blue. Okay, so our first, I'm going to use the word audit. So we know that an audit is some process that involves the financial statements. All right. We know that it involves looking at some sort of criteria, and we use our AASBs. Okay, and we know that the audit also has something to do with the audit firms, and that they have to be independent. Whoops. Is key. All right, so let me just draw some lines of how these fit together. Okay, so we've got our audit. We've got a document that's the financial statements. We're going to learn about flowchart shapes a little bit later on. There's our financial statements. They have to be put together according to some AASB criteria. The audit is actually conducted by the audit firms, and the audit firms need to be independent. Right, that's basically what we know so far. What we don't know is what happens in this box here. Okay? We're going to learn a bit more today specifically about how firms are independent and why that's important. And then we're also going to look a little bit about, on this audit side, we're going to investigate the idea of quality, which is sort of how do I make sure that all of my audit firms are doing the same thing? Okay, because to be able to have comparability between firm and firm and firm using our financial statements, we all follow the AASBs. To ensure that audit firms are doing audits of at least the same minimum quality, then we're going to look at our auditing standards as that basis today. So we're going to look at a whole lot of different things about the regulatory environment. Oh, no, I want highlighter, not pen. Let's undo that, highlighter. All right, so we're going to look at the regulatory environment, and it's quite complex in terms of the main laws. We're going to look at criminal liability, and there's a newspaper article I'm going to talk about this week. It's not in your lecture slides, but I will put that link online for you. We're going to look at some basic legal concepts. Do you guys have a law subject in your core? Yep. So where you would have learned about duty of care, all that sort of thing, we're going to delve back into that. So we're going to look at liability to clients, to third parties, our responsibilities for detecting fraud, and then how we can manage or minimise our legal exposure. All right, so that's on our first sort of part of today. So we have lots of regulation. The Australian Stock Exchange sets corporate governance guidelines, and those corporate governance guidelines apply to all of the companies or our entities that are listed on the exchange. There are guidelines about how many people should be on the audit committee, proportion of independent to executive board members, ASIC, which actually goes out and it enforces the Corporations Act. APRA, the Australian Consumer and Competition Commission. Oh, there's an error there. Let me just rule out something. The Trade Practices Act is no longer the Trade Practices Act. It's the Consumer Competition Act. That's a relatively new change there. Okay. And then there are fair trading acts in each state and territory that apply. So there's a lot of regulations on the clients that we audit and also regulations on the audit firms themselves. So ASIC actually looks after both auditors as well as the entities that we audit. So they have oversight over that entire process. So there are three main sources of liability: criminal, consumer, and the Corporations Act. So we're going to talk about each of those. The consumer one is that Consumer Competition Act that I just talked about. So it is a crime to not inform the authorities if you find your client doing something illegal. If you find them breaching perhaps environmental protection laws or financial reporting standards. So we have to report under the Crimes Act, and there can be sanctions against auditors. So if you fail to report, you could be prevented from being an auditor for a certain period of time. You could face a fine. You could be forced to requalify. So there's a number of different penalties. I've not seen any instances in the last 25 years where an auditor has actually gone to jail. So no auditors in jail as yet. They haven't done anything that serious. But in a number of instances, many have been removed from being auditors. So the Competition and Consumer Act, which was the old Trade Practices Act, has a really important section about misleading or deceptive conduct. Normally we think about misleading and deceptive conduct in regards to advertising. All right, buy this shampoo and it'll, regrow your hair, or this particular product is meant to make you 10 times more attractive to the person that you're trying to attract. This particular pill will help you lose 25 kilos in 5 days. So whatever the item is, normally we think about misleading or deceptive conduct or statements in regards to advertising. But from an auditor's perspective, when I give my audit opinion can also be subject to this particular regulation. All right, because I'm providing information that people are going to rely on. It's not necessarily advertising, but my assurance is subject to the Competition and Consumer Act about being misleading. So if I have intentionally, one of the other things to remember here is that it's often that the auditor has to have intent to mislead with their audit opinion. Okay, so it's not just, I made a mistake and something happened that I didn't know about. Generally, in this instance, it's if I'm intending to mislead or deceive. We also have the Corporations Act, which has requirements about who can register as an auditor, who monitors the auditors, which is the Companies, Auditors and Liquidators Board. All right, I think there's a D in there. Company Audit, I think there's a D there. The CALDB monitors auditors specifically and charges them and brings them to court. There's requirements about auditor independence. These ones are relatively important here. Changes to audits. You have to rotate every 5 to 7 years the audit partner on the audit. So you can't be the auditor for 25 years. So up until about 10 years ago, that was the case. You could be on the audit forever. Now we have rotation to make sure that nobody becomes too friendly with the staff. There are specific rules even on how you resign. Right? You can't just walk out of the audit. You have to notify ASIC, or the client can request that you be removed. We have our auditing standards, and our auditing standards are enforceable. All right, so all of our ASAs have force of law. We must follow those according to the Corporations Act. There are requirements on our reporting on format and information, and there's information there on how we can limit auditor liability as well. But the key ones for us are going to be those issues there. All right, so auditors have to be registered. These are all pretty basic things. Monitored, individual audit firms and big and small do get inspected on a regular basis. So in terms of monitoring, firms monitor each other. We talked about this last week in terms of the peer review. Oops. So the individual firms have peer review, internally and externally. The professional bodies monitor, and then ASIC also does their own annual inspection process. All right, and I might get you to look at some of those reports during the week. All right, now, auditor independence, and if you go to any textbook in any country around the world, oh, maybe not North Korea, because I don't know whether they have independent auditors in North Korea, but in most countries around the world, when you open an audit textbook, and I've got some auditing textbooks back from the 1940s and the 1930s in my office, they all start with some sort of phrase that says something about the cornerstone of the auditor's ability to give an opinion that people are going to rely on is this idea of independence. The fact that we're removed from the situation, that there is no conflict of interest. Right? I don't know the CEO, I'm not a shareholder, so there's no other reason for me to do anything other than tell the truth. Right? Because that's what shareholders want. Shareholders want financial statements that are free from material error or misstatement, and I can only do that if I am independent. So the Corporations Act actually requires us, to make a declaration where the audit partner writes on the audit report, I, so-and-so audit partner, and my audit team comply with the independence requirements of the Corporations Act. Now, there were requirements always in the standards and always within the Corporations Act for the auditor to be independent, but in the last decade, we've had a requirement to add a declaration. Why do we now have this piece of paper that is a declaration? And the government really didn't give any specific reasons, but research in psychology shows that when you have to sign your name to an official document, you're more likely to think more carefully about the ramifications of that. That's the reason why directors have to sign that they take responsibility for the financial statements of the organisation. That's why the auditor also signs their independence declaration. It's also concrete proof that you declare as the auditor you're independent. If ASIC finds that you've breached your independence requirements, it's a very clear, open and shut case that you've contravened the Corporations Act, because you've clearly signed a declaration, but you've breached the requirements by whatever evidence that they've got. So there's no escaping out of that sort of charge. So who appoints the auditors? The appointments are done by our shareholders. All right, so appointments are by shareholders at annual general meetings typically, or extraordinary annual general meetings, but they usually come from a recommendation by the audit committee. All right, because certainly you don't want 500,000 shareholders sitting in a room trying to argue which auditor to go and choose. So typically what happens is that the audit committee will recommend one, and then the shareholders will vote whether to, yes, go with that particular auditor, or no, to ask the audit committee to choose somebody else. It's pretty hard for auditors to resign during the audit. Usually resignations need to happen outside of the actual audit cycle, but you can't just resign. All right. If you resign, there needs to be notification to ASIC, and to the stock exchange, right? And they'll want to know why. The client might say, look, I've just refused to hire you for another year, so they've removed you because of a disagreement, because of fees, or you could choose to leave as the auditor because you might believe that there is too much risk associated with auditing that particular client. And then I mentioned rotation. Every 5 to 7 years, we must rotate audit partners. Now, this is a little bit different. So that's the Australian regulation. In the United States, we have USA rotation of audit firms. Now, why does the US rotate audit firms while we rotate audit partners? Number one, there's a lot more firms in the US. So the market is a lot bigger. You might only have one company here or one audit firm in WA that specialises in in auditing companies that mine uranium. All right, and so you might not be able to find another auditor who's suitable to do that job from a different firm. So that's why we have rotation of audit partners, whereas in the USA they have rotation of audit firms because their market is a lot bigger. We also have our ASAs, our auditing standards. Let me pick, I'm in red. And I'm going to set you a little video to watch that shows how to read an auditing standard because there's some specific requirements, similar to reading your accounting standards. These are things that must be done, all right? So I must follow these requirements as an auditor. There's no doing some and not doing others. You have to do all of them. And there are reporting obligations. So we have to report if we find fraud to ASIC. We have to report if we find that management are trading the company while insolvent. And then firms need to do their transparency reports. The auditor can also attend the AGM and answer questions. I don't think many people, the auditor has always been there, but quite often not many people know what to ask the auditor. What we are going to see that's new that's coming up, and we're going to talk about this in a few weeks, is something called key audit matters. And I think that is really going to come up and require auditors to explain more when it comes to AGMs because there's a new ASA coming out. ASA 701 on key audit matters will require the auditor to discuss or disclose in their audit opinion how they make particularly tricky judgments where there's no clear black and white rules and where they've used their professional expertise. So I'm expecting to see more queries around that particular component. So what goes into our transparency reports? Legal structure and ownership, most of them are companies, descriptions of networks, internal governance and internal controls. So what are they doing themselves to ensure that they provide a quality audit to all of their clients, to make sure that they're complying with the laws and regulations surrounding audits? So what's our liability? Just save. So we're organisations. So most audits are incorporated entities, all right? And we have proportionate liability. This proportionate liability is an important one. So that means that if we're looking at a court case, and let's say that somebody's suing and it's this much management's fault and it's this much the auditor's fault, the auditor is only going to pay their proportion of the fee. All right. Very, very long time ago, if management couldn't afford to pay their section, the auditor would have to pay the entire lot. But now we have proportionate liability because sometimes, you might overlook something, you might make a mistake. If the court finds you liable, then there will be some payment required. But if it's partially management's fault, then we have proportionate liability as well. We've also got foreign regulations. So the Sarbanes-Oxley Act is sort of similar to our Corporations Act. And their PCAOB is like our AUASB. And sort of ASIC combined because they just look at Audits, they put together the auditing standards, but they also do the inspection. So they've got sort of a dual role in the United States. But there is a cap on liability. And the cap is also related to how much the audit fee is. So you can't sue the auditor for more than, I think it's 10 times the audit fee, which often isn't, if the audit fee is $10 million, then you might have 100,000 shareholders suing for a relatively small amount of money. We also have criminal liability if we are implicit in the client cheating. So if we know things are false. This is the Enron situation, where the auditor knew that management weren't telling the truth, and they went through and they agreed that the financial statements were correct anyway. So if we use false financial statements to defraud or to cheat, so if I fail to comply with my duties and I fail to report this information, so if I know that's going on and I fail to report, then I could be in trouble, and if I fail to be independent as well. Now, who remembers the case where we use the reasonable person test? What would be reasonable to expect a person to do? And so when it comes to auditor liability, we have our auditing standards, and to determine whether the auditor actually made a mistake or not, we use the reasonable person test or the reasonable auditor test, in which the lawyers or the court give an expert auditor the same information that the auditor who made the mistake had. We get them to do that same test again and see what their conclusion is. If their conclusion is the same as the original auditor, even if that conclusion is incorrect based on further knowledge that we get down the track, then that person has exercised reasonable skill and care. All right? And so it comes down to those important things of professional skill and care. What does it mean to have professional skill and care? And we're going to find out about that in APES 110, which talks about what it means to have those professional skills. We're going to look at what those actual skills are. Partners are liable for what their employees do. So it's the partner that actually signs their name on the dotted line, and they're liable for anybody that works underneath them. Okay. Other firms, so if you engage another firm, let's say you're the Australian auditor of a multinational company and you send out some work to be done by another firm in Indonesia. If they've done the wrong thing, then you as the partner are liable, even though you weren't directly supervising that work. Or if you engage a specialist. You might not know much about reading mining reports, so you engage a geoscience specialist. If that specialist makes a mistake or is intentionally fraudulent, then you could be liable for their work as well. Now, where's my... The other part to remember, that last part there, says lack of privileged communication. And normally when we think about privileged communication, we think about what sort of profession? Between a client and that professional, any discussions they have are privileged? Doctors and lawyers, yeah. So we normally think about that in regards to doctors and to lawyers. That same privilege does not apply to auditors. Okay, so anything that we tell our clients tell us, can be discussed or can be communicated to ASIC. So there's nothing that says, oh look, we have to have confidential information. If the client tells us that they've been miscalculating revenue for a certain amount of years, we have an obligation to report that. There's nothing that we have to protect there. So we do have liabilities to clients. Right? As an auditor, I engage in a contract. Let me just check what colour pen am I using. Let's use purple. All right. So I engage in a contract, and that contract is between the auditor, so it's usually the audit partner, and the audit committee. All right, and if the audit committee is small, it might be the board. Okay, I don't engage in a contract with my eventual clients, which are my shareholders, because I can't send a contract around to 50,000 shareholders all to sign and send back to me. So I have a contract with the audit partner, and my contract says I am going to do an audit according to the Australian requirements by this particular date for this particular fee. Okay, so if I fail to do my functions with, and there's that word again that's come up, due care, then I could be liable to the client. The client can sue me. All right. If I breach any other part of my contract, if I provide my audit report late, for example, then the client can sue me, and then they can also sue me under the tort of negligence. All right. So if we think about the 3 orange bubbles that we had before of criminal codes, contract and tort, the client can sue us for breach of contract or under the tort of negligence. Now, who can remember the original case that established the tort of negligence? This was a very long time ago about somebody taking a drink. Donahue and Stevenson, yep. So if we think back to the snail in the ginger beer bottle, that was the original idea about owing somebody a duty of care. Okay, so the idea of a duty of care comes from originally the tort of negligence. Who could we expect to drink the ginger beer? What is expected of us as the provider? So we have an unavoidable duty to report to shareholders as the clients, not the directors. All right, because the directors are meant to be the shareholders' representatives. Okay, so my board, I'm always thinking about my clients as the shareholders, even though I only deal directly with the board of directors. Okay, I have a duty to use all of my skill, care, and caution. All right, so this is the reasonable auditor test. And then I have also specific duties and responsibilities. Now, out of Kingston Cotton Mill, there's also some requirements about fraud, which I'm going to touch on a little bit later. It's probably most well known for the requirements about fraud. And the Pacific Acceptance case was really the first case that spelled out exactly what an auditor's responsibilities were. We had general definitions about the auditor is meant to check that the financial statements are true and fair, but there weren't many instructions on how to do that. In 1970, they came up with some very specific lists of the auditors must collect evidence. The auditors must report on the entire year. You must have a plan. You can't just sort of go in and go, hey, let me see what I'm going to audit today. So a lot of the things that we're going to talk about that we're going to take for granted as the basics of doing an audit weren't actually put into law until we came to 1970. And until that point, most audit firms had their own guidance and auditing standards. They all had the same accounting standards, but there were no set rules and regulations for auditors. We have duties to inform management if we find any issues within the audit themselves, within any audits. So that could include things like any weaknesses in their processes that might encourage fraud or theft. I might tell them if I found fraud, something that's not on the list. I'll add that. Under ASA 240, I also have a duty to report if I've discovered fraud. Okay? I have a duty to report to the board of directors if management are not being helpful in the audit. If we think somebody is stopping us from getting evidence, then we also have a duty to report. Now, sometimes it's partly the auditor's fault that things go wrong, but then it's also partly somebody else's fault. And that's the idea of contributory negligence. So contributory is that idea that somebody else contributes. So if management very specifically lied, right? They told us a falsehood and they created false documents that we then used and relied upon those to make our opinion or our decision. I might be at fault because I might not have detected that the documents I was looking at were false. But it's also partly management's fault if they've created the fictitious or the fake invoices or bills or whatever they might be. So the AWA v. Daniels case, and that's this one here, AWA v. Daniels, which will be in your textbook, had an instance where the auditor was liable because they took management's verbal evidence and they didn't go look at any backup paper evidence. Management said, oh, yep, here is what's happening, blah, 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 blah. Trust us. The management very clearly lied in this situation, but the auditor didn't go and hunt for more facts or get confirmation of that verbal evidence with someone else. So in that instance, they were both at fault there. So we need to look at whether there is the probability that harm would occur, the seriousness, the burden, and the social utility of the risk-creating activity, which is not something I'm going to get you guys to look at. Okay, this is the hardest part, and this is the part that probably, for students, requires the most getting your head around. Because when the auditor has a contract with the client, contract law is pretty specific, right? You breach the contract, you sue, or one of the parties sues for the things on the contract. But what about shareholders? Shareholders are not people who sign the contract. They are our ultimate client, but technically they're not party to the contract, so there needs to be another way for a shareholder to be able to sue the auditor. And we do that through Donoghue and Stevenson and the tort of negligence. Oh, let's undo, that doesn't sound right. Negli. I think that's right. 4 days off on a public holiday and too much chocolate, and I can't remember how to spell. So this is the idea that we owe a duty of care to a third party. Now, most of the time, that third party is going to be shareholders, but who else could be third parties who are outside of the auditor-client relationship that might want to sue the auditor? Any ideas? Lenders, yep. Any others? Customers? All right. Even the government, potentially, could be a third party using the financial statements. So anybody who uses the financial statements for information to aid their decision-making has the potential to sue the auditor if the auditor makes a mistake and they've relied on that auditor's information. So we have to think about some legal concepts, and the first one is foreseeability. Can I foresee or expect that third party to rely on the financial statements? Okay, and so we've got a number of different cases. Headley-Byrne was a UK case. These other ones, MLC, Scott, and the Fasteners are all Australian cases, which says that the plaintiff had to have relied on the audited accounts and it had to be reasonably foreseeable. I have to be able to expect that that particular third party will rely on the accounts. So who could I reasonably expect to rely on the third party accounts? Under these cases, generally, we can reasonably expect shareholders to rely on the accounts because we know we produce the report with them in mind. Okay? Some people might say, well, what about lenders? Only if the auditor knows that this particular audit report is going to that specific lender. All right? Because you might have a general set of financial statements that you could send to 20 different banks to try and get a loan. Does that mean you're liable to all 20 of them? Not unless you knew that it was going to happen ahead of time. So this is the key one. So you've got to have foreseeability, but one of the key items is the idea of proximity. And the idea of proximity is that the third party must show that the auditors knew or reasonably foreseen, that was the previous slide, that a particular party would rely on the auditor's work, and then there must be a real relationship. Okay, so there must be a real existing relationship between those parties. And we know that that exists for shareholders because the shareholders are the ones who ultimately use our financial report. And our audit opinion actually says, dear shareholders, or to the shareholders of Woolworths Limited, to the shareholders of BHP Billiton Limited. So it's very, very clear that we are in a relationship with our shareholders. It is less clear that we might be in a relationship with parties like lenders. Right? And proximity is the key here. It's the hinge pin that makes or breaks cases. You need to be able to prove, or the third party that's suing needs to be able to prove that they were in a real relationship with the auditor. Okay, now let me just check if it's on the next slide. All right, I don't have it there on the slide, but on the Asander case, this is one I want you to make sure that you go and read for homework. That's a really important one. In the Asander case, the judge actually said that the auditor must, and I'm going to type this out so that you've got it exactly, entice, induce, or encourage the third party to rely on the financial statements. All right? So to have proximity, there needs to be enticement, there needs to be encouragement, or there needs to be inducement in the audit report, where the auditor has to say, hey, people X, please come and rely on my financial statements. All right? In the audit report, we see that is very clear for our shareholders, that we entice them. We say, dear shareholders. But we don't say, dear banks, or dear community groups, or dear customers. In that instance, there is no proximity. All right, so how do we figure out whether we owe or whether the auditor is liable? Step number 1, do we owe a duty of care? So that duty of care could come from a contract, all right, or do we owe a duty of care under the tort, which will come down to usually that concept of proximity. All right. Then did I breach the duty of care? Did I make a mistake or an error? That's what this bit here is. Breaching the duty of care is, did I make the mistake or error? Was there a loss? Now, importantly, that loss must be financial. Okay. We do not allow people to sue for emotional loss. All right. So emotional loss, not allowed to sue for that. Oh, I'm devastated because I invested all my money in these shares and it was a bad choice and then the company failed because part of the auditor's fault and now I'm emotionally scarred for the rest of my life. No. So it's only financial and not emotional. And there has to be here something that we call a causal relationship. Okay. That means that there must be cause and effect. That's another way of putting it. Cause and effect. Okay. That means that what the auditor did, auditor's mistake, led to incorrect audit opinion relied on by third party, and then the loss occurred as a result. So if the auditor made a mistake on something very, very small, all right, and it didn't end up affecting the overall end opinion, then there would be no liability there. So we have to go through these 4 steps. So it really is 1, 2, 3, 4 steps. But the biggest part where you do the most work is this bit, figuring out, do we owe a duty of care? It's pretty easy to figure out whether there's been a breach, whether there's been a loss, and whether there's cause and effect. But this part, who do we owe a duty of care to, and the idea of proximity is the big decision point usually in these cases. Now there is something called a privity letter, and AGS 1014 I don't think is in existence anymore, but a privity letter is when a third party writes to the auditor and says, "Hi auditor, can you please sign this letter that says that the general purpose financial statements that are meant for shareholders are going to be suitable for me, the lender, to use in my decision making." All right? Because when you sign the privity letter as an auditor, what you're doing is you are creating proximity. Now, if you're an auditor, do you want to sign these letters? No. All right. And when I was an auditor at PwC, or Coopers and Lybrand, and then PwC, I actually, I got to this topic at uni because I was doing uni part-time, and I thought, I wonder what PwC says when somebody sends us a privity letter. So I went into our big database that has all of the different standard replies to form letters and things that we use, and I couldn't find one. That's a bit strange. What do we do when someone sends us a privity letter? So I thought, okay, I'm going to go to the department that handles drafting all these standard letters, which is about methodology and legal. So I went to them and I said, okay, what if somebody sends us a privity letter? What should I reply? And is there a standard response? And they said, well, we would prefer, if you ever received a privity letter, to send it to them. Don't ever write back. All right? Because even acknowledging that you've received the letter, at the moment the courts don't take that as proximity. But it may be that a judge might, in some point further down the track, interpret the fact that you've received the letter as and acknowledged and said, oh, look, thank you for the letter, but we're not going to sign it. Here it is, unsigned back to you. The possibility that you've even sent that response could in the future be deemed to create proximity. All right? And so I asked a partner, well, what do we do with these privity letters that come to us? And he said, oh, we just shred them, like they never existed. All right? We don't even want to acknowledge that somebody has even sent us a privity letter request. Now, AGS 1014 actually says when we get one, we should reply back and say, thank you for sending us this request for a privity letter. We are not going to provide one. But in practice, my understanding is that this is a guide statement. It's not something you have to do by law, but most firms just throw them in the bin like it never happened, so that there's not even a chance of creating proximity. Because the auditor is exposed to the government through ASIC, it's exposed to shareholders through the tort of negligence, it's exposed to management via the contract that we sign. If we expose ourselves to more liability by saying, okay, now we could be liable to lenders or buyers or other third parties, is that going to make the auditor's job easier or more difficult? What do we think? More difficult. All right. And if it's more likely that we're going to be sued more often, do you think our fees are going to go up or down? Up, because there's now more risk. Okay. If there's too much risk, audit firms will stop auditing. All right. So if we're exposed to too much liability, the audit firm has the option of just refusing to do audits and then just doing tax and consulting services. So there is a fine balance between having too much liability and not enough to try, and that's the court's decision to make. The Corporations Act prevents me from disclaiming my liability to clients, so I can't write a little disclaimer that says, client, you can't sue me. It does apply to third parties, but again, regardless of this, the key needs to be proximity. If a third party is going to sue you, they have to do it under the tort of negligence, so proximity is the key. Now, the audit report is going mostly to the shareholders, not to any one specific shareholder, but to the body of shareholders, and it's about historical information, all right? So it's not intended as advice to potential investors. It's only intended for those people who are existing shareholders, all right? So what are our responsibilities for detecting fraud? We have an auditing standard down here, ASA 240. It's our standard on fraud, which actually came out of the Pacific Acceptance case. But we have to have reasonable care. It's the reasonable auditor test. And this is one that, the next one is something that is in every single textbook around the world. The auditor is a watchdog, not a bloodhound. What does that mean? Okay, so your watchdogs are your German Shepherds and your Dobermans, right? They sit there, they spend all day looking around, and if they see something that looks unusual, they're going to go off and go, alert, 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 go and investigate. All right? The bloodhound, if you're looking for truffles, all right? You get the bloodhound and you crisscross the bloodhound over the entire territory. Okay? So the bloodhound is specifically searching for fraud, whereas the watchdog is keeping an eye out for anything that flags as a risk factor for fraud. And that's the key difference. The auditor is this one, the watchdog. I'm keeping an eye out for anything. This is my red flag. All right, that is a red flag that says, hang on a second, this could be something that could be indicative of fraud. All right, and I'm looking for those red flags. I'm not a bloodhound because a thorough fraud investigation, if you're going to fraud investigate a set of financial statements, that's a 2 or 3 year job. You don't have 2 or 3 years, you have 6 weeks. So my job is to keep an eye out for anything that looks suspicious. And if something doesn't quite gel, then I go out and I look at it. But I'm not trawling through the financial statements deliberately searching for fraud, because it'd take me forever, and it's quite a different way. When we do fraud investigations, it's very different from general audits. Now, ASA 240 actually has a list of red flags. Red flags in the appendices. All right. So if you're wondering what sort of things could be a red flag, go into ASA 240 and you'll see a list there. Now, how do organisations manage their legal liability? Well, it comes down to, at the beginning, client acceptance. All right. So you want to only accept clients that have integrity. So you want to probably screen those clients really carefully. Last week I said I probably wouldn't want to be an auditor in any company Donald Trump is heading up. I checked on PolitiFact, and when you look on PolitiFact, of all the statements that Donald makes, only 3% are true. 3%. So I'm pretty sure if I was looking at one of his companies and he approached me to audit it, I probably wouldn't go there, just because there's a greater risk of things going wrong. There's a couple of other things that we can also do. We can also make sure we have qualified personnel. Right? That's why there's lots of rigorous training and supervising, which means that's why you do the CA program or the CPA program. We have to follow our auditing standards. Right? And then we have internal peer review and external reviews to make sure that those are done correctly. Independence in conjunction with the Corporations Act of 2001. And then understanding the client's business so that nothing is blindsided. Right? So that you're not blindsided by, oh, I didn't know that these guys also were involved in child manufacturing in Indonesia. All right? So when you go to, and this is part of that screening process up the top here, let me change pen colours. When you're screening your clients, you want to make sure that you understand their business, that you know what they do, how they do it, where they do it, why they do it, so that you're not caught off guard. You know, certainly Apple took a little bit of a hit when it was discovered that people in their factories in China would rather commit suicide than keep working in some instances. Or when Cotton On, do we all know the brand Cotton On? Was found to be using child labour in countries like Sri Lanka and Bangladesh. That doesn't bode well for a lot of other factors around the organisation. So if you think they're a little bit dodgy, then there might be a reason to avoid those particular companies. And that's because the auditor's biggest asset is their reputation. All right, and that's something that they need to protect. And once somebody has sort of flung mud and accused you of doing something, even if that accusation turns out to be false, that does create seeds of doubt. So managing that reputation is really, really important. All right, we saw that in Miley Cyrus. Miley went from Hannah Montana to the Miley that we know now. And she very intentionally shifted her public image. Britney Spears, not so much. It just tended to happen one disaster after another by accident. But she has the reputation that she does. But you can't remove the pictures of the internet of you going crazy and almost dropping your baby coming out of a car. You can't unflash anybody from not wearing underwear getting out of a limo. You can't unshave, people can't unsee that information. So our biggest asset is our reputation. And the power of that reputation means that firms, the big four firms, charge increased fees simply because they have their reputation. So because they can charge that fee premium, because they're reputable, it becomes one of their biggest assets. And screening clients is something they do very, very carefully. One of my tutors from a very long time ago is a partner at PwC now. And he was surprised that when he wanted to bring on a new client, he needed to go through a 150-question checklist of information he had to provide before the executive would decide whether to approve or not approve that particular entity as a client. So they wanted to look into all sorts of things about directors' backgrounds, past history of the organisation, products, where the manufacturing is done, just to be able to understand the risk. So we want to make sure that we do quality audits, we document our work properly. An engagement letter. Now the engagement letter comes out of ASA 210 and it is essentially our contract. All right. So it's a standardized contract that everybody signs. Of course, before you do any business, you want to make sure you've signed a contract, that you have insurance. So professional auditors carry indemnity insurance, just like doctors and lawyers have an indemnity insurance in case if you're a doctor, you cut off the wrong arm from somebody. You have insurance to pay out for that. Audit firms also have insurance for giving the wrong opinion or being sued. Obviously, you want to minimize being sued because the more you get sued, the higher your premium is each year. So this was a new article that is not on your slides, but I'll put it online. And it only came out I think it was Friday. So on the 23rd of February, Federal Parliament passed into law the Crimes Legislation Amendment, all right, which makes it prohibited to make, alter, destroy, or conceal accounting documents. So if you're falsifying accounting documents, destroying them or concealing them, that is now a criminal offence because you're engaged in also misleading people. And that was the Enron thing, right? Arthur Andersen were there shredding documents as the Department of Justice was trying to serve them a warrant to get access to all the information. So it's now illegal there to destroy or even create a fake accounting document. Okay, so how do we get into quality and our ethical requirements? And ethics comes in under APES 110. That's a standard. If you haven't downloaded it, I'll put up a link from where you can download APES 110. You'll definitely need to look at that next week. So an annual audit is the cornerstone of corporate governance to make sure that shareholders have accurate, reliable information for which to base their decision making. Okay? And corporate governance is not just the auditor. The corporate governance is government law, it's inspections, it's directors, it's regulators all working together in the name of moving business forward. So we have specific emphasis within Australia. So it's about removing conflicts of interest. Okay, and that's where independence lies, to have accountability and transparency. So our quality of an audit is how well we detect and report material misstatements. And a misstatement is anything that's wrong within the accounts. Material is a particular size. So we're only looking for big things, right? I'm not looking if you've stolen like a $1 pack of Post-it notes or $2 worth of toilet paper, but I am interested in if you've embezzled $2 million, okay? So the quality is how well the audit team detects and reports those material misstatements. Detect means find, all right? So that's pretty basic. So it means how well we do to find them, and then report them, which means how likely are we to request management make a change to the financial statements. Okay. So detecting reflects how well I can do my job. Am I competent? Reporting reflects whether I have the integrity to say to the client, you must make this change. Okay? Now at Enron, they did lots of detection and they found lots of things wrong, but they failed to report. Right? They said to the client, oh look, we found these errors. The client offered them essentially a bribe and they said, oh, well, I'm not going to say anything. So we could have failure in audit quality from a failure to report, or if I can't actually find the errors because I don't have the right skills, and therefore that gives me nothing to report, then that's also an audit failure. So improving reporting comes from enforcing our ethical standards and reinforcing that within our audit teams and making sure we're independent. Detection comes from developing our skills, and that's part of what we're going to do here. We've got the ASX Good Corporate Governance Principles that they require firms to do. So these are things for audit clients to actually go and do themselves. So we have this idea of quality, that the audit has to find errors and then report them. But then there is something that we call an expectations gap. And when I first started doing audits, and my parents have always owned a lot of shares, my dad fancies himself as a bit of a day trader. Not all that fantastic. He's reasonable. But, I said, they'd get all these annual reports in, and one day I saw Mum with a whole stack of annual reports. I said, Mum, what are you looking for in the annual report and the auditor's report? What do you think the auditor does? And she said, well, I think that if the auditor signs the audit report, that must mean the auditor has done a good job for the year. Right? A lot of the general public think that the auditor's job is to give the seal of approval on whether management are good at their jobs, when in fact what the auditor's job is to actually determine whether the financial statements are true and fair, are free from material misstatement, even if the company is being managed terribly by managers, even if the company is having its biggest loss in 100 years, as long as they're being truthful about that, we give them a big green tick on the audit report. So there is a fair gap between what the auditor actually does and then the expectations of what the auditor does when it comes to the public or the government. And that's often amplified by the news. So when a company collapses, journalists usually write, what were the auditors thinking? Why didn't the auditors tell us about this beforehand? And so there's a lot of misconception about what my role is as the auditor. I'm not searching for fraud, right? This is the bloodhound watchdog thing. I'm not searching for fraud. I'm keeping an eye out for things that could be suspicious, and I'm required to do my job appropriately. So there is that gap. What causes the gap? People don't understand what an audit is about. It's always easy to find out the answer in hindsight. Oh, of course, I should have noticed that so-and-so was doing X from these particular things. Often people who complain have self-interest. So, newspapers want to sell the number of papers or increase their subscription. So certainly they're going to write headlines that might be a bit more inflammatory. Auditors might not want to tell people what they do, that expectations of society has changed, and that there's a misunderstanding or ignorance of roles. Now, the change in society is reflected by changes in the decisions of judges. Okay? And certainly we know that as society's expectations of everything change, then so do the laws that we might create and the decisions that judges might make to uphold or enforce those laws. So certainly in the pre-1970s, churches didn't think it was important to report child sex abuse. Right? They even thought it was more important to pay off families and move offending priests to other parishes. And they didn't think it wasn't something that was worth reporting. Now, we know that, and the public perception on that is very much changed. Right? There are greater penalties. The court has introduced greater penalties for people involved in those crimes and involved in being associated with those crimes, because our perception of what we think is acceptable and not acceptable to do to another human being has changed. And it's the same here with the law around auditors. Right? When only a very small number of people owned shares and it was only the very wealthy, then perhaps the public didn't take as much interest in what auditors did compared to now, where probably for all of my local students, most of your parents probably at some point received shares in Woolworths or Telstra or the NRMA, right? Because most people were members of one of those organisations. And so as the profile of our shareholder mix changed, then so did the importance of what the auditor did or does. So we have a big lack of understanding between the users of the financial statements and the people that prepare them, because they don't understand the difference between a business failure and the audit failure. So when the business fails, sometimes that's just management doing a crappy job. The audit is a failure when I fail to either detect the error or I fail to report. All right? Failing to detect might be my fault, in which case I'm negligent. Failing might be because management created a whole lot of fictitious documents that were so good as forgeries I couldn't even pick the difference. So there is some difference between business failure and audit failure. Most companies fail because of bad management. Very few fail because the audit, something happened incorrectly in the audit. All right. So certainly Enron and HIH are two big examples, but they represent less than 1% of company, Enron represented less than 1% of company failures in the US at that particular point in time. So most companies fail under their own steam. So what does it mean to be competent, to be able to do that detection work? All right, because that's our job. Anybody here like watching those two Sherlock Holmes shows? One's called Elementary, and the other one I think is the English Sherlock Holmes. No? Yes? I love those. And that's pretty much what we're doing, but without going to all the fancy places or all the weird, Sherlock Holmes stuff that he does on Elementary. But that's our job. Our job is to look at evidence and look for things that are out of place, to try and find account numbers that don't look quite right, look at the evidence and try and confirm what that actual number should be. So we could be looking for something that's missing, we could be looking for something that's out of place, something that feels unusual. Now certainly we're not, sniffing paper or licking chewing gum on the undersides of chairs to figure out what exactly is going on, but we're going to use those same detection and deductive skills to be able to identify parts of the accounts that might be misstated. So we need two things. Technical knowledge. Technical knowledge comes from going to uni, and it comes from doing your professional qualification after university. And quality control, which happens at the firm level, as well as at your industry, at your professional level. I have to be able to interpret complex evidence, and that is a skill that we have to learn over time, not something that is easily done. And then the professional bodies provide guidance on what it means to be competent. They also provide training programs for firms. PwC and all the big firms do their own training, but smaller companies often use the CA's training programs there so that we are competent, that we go in and we know what we're doing on the audit. All right? We're not quickly YouTubing to find out what am I supposed to be doing here at this particular time. So ASA 220 says that we have to have quality control. There has to be somebody in charge. That is usually our audit partner. All right, but everybody gets involved in ensuring that all of our documentation is done correctly. We work as a team to brainstorm on what could be fraud. We think about our ethical requirements in APES 110. All right, we look at accepting and continuing client engagements, so we screen our clients really carefully. We assign the teams correctly, so people who have the right skills, that right knowledge. We perform the engagement correctly, so we actually do the task, so this is the doing bit. And then monitoring, making sure that we've got that review process. Somebody is doing the checking. So we also have ethics. Everybody's ethics and moral values are going to be slightly different, but we all have the same general underlying principles, right? It's not nice to kill people, it's not nice to lie to other people, it's not nice to steal. Those are generally the basic ethical principles that most people live by. Our profession has a set of ethics that we compile into our ethical regulations, all right? So there's some reasons why people act unethically. We don't need to go into those. But there are some common rationalizations. Everybody's doing it. So this is sort of, it might be sneaking in alcohol to a music festival. Oh, look, everybody else is doing it, so I might as well do it. If it's legal, it's ethical. Something might be legal but not ethical to do. And if we're unlikely to be discovered and there are no consequences, so if there were no consequences to speeding, there were no demerit points, there were no fines, would you stick to the speed limit? Probably not. Okay. If you could cheat in the final exam, so say in the final exam it's open book, but before when it was closed book, if there were no invigilators, none of those exam supervisors, and there was no chance of being caught, everybody would probably do it. So there are reasons that people use to try and rationalise unethical behaviour, reasons that they tell themselves because they know they're doing the wrong thing and they're trying to convince themselves that doing the wrong thing is okay. So how do we resolve ethical dilemmas? We look at the facts, think about the ethical issues, identify alternatives, weigh up the balance, pros and cons to all of those parties, and then decide the appropriate action. An example here for accounting and for our audits could be that if we discover a new piece of information about the client that could affect their future performance. All right? It's not concrete yet, but it could happen. Should I ethically report that to shareholders in my auditor's report when it could cause a bit of a downward spiral? Or do I hold that back? Sometimes it's not an easy decision to make. Within the profession, the firms have ethical experts, and there's also an ethical centre that you can call. So if you get stuck on something, you don't know what you should do, then there's also a hotline you can call. So we have 5 components of ethical behaviour that we need to consider. Integrity, objectivity, professional competence, which is skill, remaining confidential, and then acting in a professional manner. Right? Integrity, that's that honest. So integrity is also, the idea about acting honestly. Objectivity, which is related to our independence. The professional competence, which is about having the right skills. Confidentiality is obviously keeping our mouth shut. And then acting in a manner that's professional. All right, so if you're going out on a Friday night to a club, you're probably not going to dress like that to go to work at a very conservative investment banking firm. You probably wouldn't be making loud personal phone calls at a client office. You probably wouldn't swear or use offensive language or racist language against any particular party at a client site. So APES 110 has a general statement about what is expected, but I'm going to get to what we call the 5 threats to audit independence, because we're going out of time today. What happens if we don't enforce? CAANZ can force you out or fine you, but they don't ever publish the names. It's a bit hush-hush. So if you get kicked out for breaching the ethical guidelines, your name doesn't get put up in lights as a bad auditor. It just says, we've removed this many auditors for infringements of APES 110, which is a little bit, I don't think is right. I think we deserve to know who is not doing the right thing. So there's 3 parts to APES 110. General application of the code, members in public practice. So those are the people doing your audits and your tax. All right, members in business, so those are people working for commercial organisations. So if you're an auditor at if you're an accountant at Telstra or Woolworths or Unilever, then that's you there in Part C. Okay, so we've covered those. So we need to think about, and the approach that they take is they say, let's look at threats to the principles of what we're going to look at. And these are the key ones. These are what I want you to think about for next week. All right. These are our 5 main threats to independence. Self-interest. This is greed, right? I own shares in a company and I audit that company. I could use that information. So self-interest. There's no way I should be self-interested. I should always have independence. Number 2, self-review. This is the student marks their own exam example, right? I should never do work for the auditor and then for the client and then audit it myself, because of course I think I'm going to do a good job. Advocacy. I cannot act on the client's behalf. All right? I could not act on their behalf in a negotiation, for example, because I'm the auditor, I'm meant to be independent. Familiarity. Now, this is where the rotation requirements for audit firms come from. Quite often, over a 20-year period, audit firm and CEO become very friendly, right? Over that 20 years. They send their kids to the same schools, their wives play tennis together, they play golf in the same foursome every Saturday at the same tea time. And over that 20-year period, you become friends with the CEO. And then when you discover that CEO has a massive gambling problem and has stolen millions of dollars from the company, now you're in a tricky situation because you're the auditor and you're also his friend. So what decision do you make? Decision to keep the friendship, knowing that your families are very close together. You might have bought shares in a yacht together, so if he goes down for embezzlement and fraud, then there's going to be a whole other kerfuffle. Or do you stick with your ethical principles? So that's why we have the familiarity requirement, and then intimidation. All right, so in a lot of circumstances, clients will often try and intimidate the auditor to get the opinion or outcome that they want. So the standards, or APES 110, looks at safeguards, things that you could implement to make sure that these don't happen. It could be a very strict rule that says, as the auditor, you cannot do the accounting. Or it could be a rule that says all employees must register their share ownerships with HR, and that's put in some sort of file so that when they're scheduling new own clients, there can be no conflict of interest. Okay, so when my husband worked at QBE Insurance, I couldn't do the audit. So I used to be on the audit team of QBE Insurance, but once he took a job there, I couldn't because he was involved in the accounting. And if I discovered that he'd embezzled a whole lot of money, I would have quit my job and we would have escaped to a Spanish island somewhere. I'd like to think I would have turned him in, but that's a difficult decision to make, especially if that was your spouse. So the profession, legislation and regulation create safeguards and specific rules, and then firms also create specific rules. So there's heaps of them. When can you hire an auditor? What is a conflict of interest? What sort of fees can you take? You can't accept shares in a client as payment for doing the audit because suddenly then you're no longer independent. Gifts and hospitality. If a client gives you, I don't know, an Aston Martin as a gift, unless they're also giving everybody else Aston Martins as gifts, not really acceptable. Fruit basket, acceptable. Okay, holding clients' assets, being objective and being independent. So mostly our stuff is here in terms of being independent. But if you're auditing a bank, you can't get a preferential discount on a home loan rate from them. You can work and audit a bank if you've got your regular home loan through them that's not been obtained through special channels. So independence is about being unbiased, it's being objective, it's professional freedom and free from bias. We must be independent, and we've already talked about the declaration that we have to do. And we have to be independent in two different ways. We have to be independent in our minds. So we have to think as if we're independent, and then it also has to appear independent as well. All right, so even the appearance of impropriety can create issues. So we need to both be independent in our minds and also our appearance outwards other people. So our threats to independence are those 5 threats that we talked about earlier. So I write the 5 threats, and there are some specific examples down here. How are we doing? Okay, I've got to hurry up. How do we maintain independence? The audit committee is made up of independent directors. Okay, we have our auditor rotation every 5 to 7 years. We've got our documentation, and if we are not independent, then we can resign. All right, so that's it for this week. I know it's a really huge week. You've got a really huge week to study for your quizzes. Quiz scores for this week should be up tomorrow afternoon. All right, so if you're doing your quiz this week, scores will go up tomorrow afternoon.